Our next topic involves one of the most important points in a case, the beginning. When facts come together for the first time and morph into a legal theory, the successful application of which requires sound due diligence and investigatory methods, application of corporate governance, or lack thereof in many cases, and earlier discoverer strategies which precede the filing of litigation. Presenting on this roundtable topic of pre-filing due diligence, corporate governance, and early discovery strategies is R.J. Cronkite, Bernie Fuse, Thomas Frazee, Sean Fitzpatrick, and Mark Rossman moderating. And please feel free to post dialogue and questions freely in the chat box throughout all of our discussions tonight.
Comments about ferns, that we should be sitting between them?
Yeah, I mean,
What's that all about?
well, we couldn't get the fireplace.
I better get my
That would
mask
be
on.
not legal. So,
All right, so do we have all our speakers here? Tom Frazee, are you in the house?
I am.
All right, Tom. I thought that
oh, there he is, right there.
since I usually spend a lot of time answering your hard questions, I just kind of get the ball rolling asking you what it is that you like from lawyers at the beginning of one of these cases, these fiduciary breach oppression cases, as the expert who will ultimately possibly be testifying in the case.
Yeah, for me, this, and I say this with some seriousness, that I think the best thing to start with, frankly, is an introduction to the client, and the time to actually spend talking with that individual as to what it is that they're concerned about. One of the things, as you know, you deal with financial issues in a case like this, some of them end up relating to liability, some may relate to remedies that ultimately are valuation focused, or that may relate to damage claims or things like that. But my experience has been that really, you know, that first introductory discussion with the client helps to give you some understanding of sort of which bucket they fall into. And my experience has been that, you know, typically you've got three types of clients at that early stage. One is one that's very uninformed about the finances and the operations, really doesn't have a lot to tell you specifically about the things that you might care about as an expert dealing with the financial side of it. The second is somebody who's got a lot of information and, you know, may not fully understand it all, but has a lot of information and can fill in a lot of holes. And the third is someone sort of in the middle who maybe knows enough to feel angry and maybe has enough to sort of point you in the right direction, but maybe not explain it well. And so from my end, that initial discussion with the client is super important, helps to understand whether the things that we should be asking for and talking about further relate to, you know, dividend policy or related party transactions, or the size of a potential valuation of their interest, if that's something that they're ultimately looking to have as a remedy. And so that initial discussion helps to focus, number one, on their understanding, but also then helps, I think, as a practical matter to target follow-up discovery requests or follow-up, you know, reviewing specific documents that they may have in their possession already. And obviously, you know, that's probably a good segue into, you know, thinking a little bit about the types of documents that you might want to ask for pre-litigation. And those types of documents, obviously, there's a statute that kind of lays out the easy ones, but frankly, the easy documents, the ones that are specifically authorized by statute, usually don't give you enough information to really understand enough to understand that whether the client has a great position or a weak position, or you just don't know. So those would be the, you know, the things I typically look for right out of the gates when trying to frame not only what I'm looking for, but also to help that client understand a little bit more about the battle they may be in for and the issues that they're going to have to deal with.
All right. Sound is low. We good? Take what down? Oh, yeah, you can take that down. Yeah. All right. Okay. Sorry about that. So litigators on the panel. Well, how do you feel about working with your expert earlier rather than later in this pre-filing phase of the case, and how it can help or possibly burden in some ways.
Hey, Mark, it's Bernie. I'll piggyback on Tom. I mean, the problem we sometimes have as lawyers and dealing with clients is sometimes clients don't want to spend the money on an expert early on. They don't see the value, they penny pinch, and it's sometimes tough to get them to not pay just for your services, but also for an expert to come in. But if you take a 30,000-foot perspective on it and really talk with them and explain it to them, it oftentimes is money well spent. And really to piggyback on Tom, and for the law students out there, you know, you're walking into a case and you don't have the fact pattern yet. It's not given to you. You have to really create and understand the true fact pattern. So to Tom's point, you know, you really need to get in there and interview your client and find out the good, the bad, and the ugly. And sometimes I analogize it to really deposing your own client. They've called you for a reason, but they don't really know all the details. And you really got to press them on what they know, what they don't know, and where you're going with it. And on those three buckets, I mean, Mark, you and I had a case recently. You know, sometimes you'll have a client who has no idea what's going on, and you don't have the pieces to the puzzle or any pieces. But we've had experience recently where we had a client who knew the operations, knew the finances, and also happened to be an attorney. And he had a chronology ready to go. Everything was there. And even then, we had to dig into it more. And we were able to get this person to understand the benefits of bringing in a forensic accounting expert, someone like a Tom, to come in and analyze the documents that you have, the operating agreement, the buy-sell, the financials, and really give at least an initial opinion on what they think the value might be worth and what else you need to really further develop that. And, you know, a couple hours here and there is worth the expense than getting a litigation started and ending up down 6 months down the road, you know, with a dud of a case. So I guess, Tom, from your expertise standpoint, how do you go about helping the attorney and really helping the client understand your value at the beginning as opposed to the middle or the end?
You know, it's a good question. I think that from a personal perspective, I always, you know, am frankly willing to spend a little time up front to try to help not only the attorney understand whether they have a case and potentially the value of that, but also to help that client, especially with regard to setting expectations. And so that initial conversation really, frankly, from my end, isn't about fees, because that really isn't, in my view, the driver. It's to try to go in with your eyes open. And I think more than anything, you know, the types of issues that you can identify very early on almost always demonstrate value to a client who's about to embark on a process that is not only financially important to them, but also, as you know, emotionally draining. Sometimes it can be a distraction if you're in business and you're not in the business of litigating. These kinds of cases take time. So I think the value add early on is actually very easy to demonstrate, because it helps the client to set some reasonable expectations, to understand some of the things that they're in for. Frankly, it's really important, in my view, in scenarios where you have a client who really is uninformed as to the nuances of the business. I'll give you an example. You know, how many times have you seen a client come in and you ask them, for example, you know, how many operating agreements are there? Or is there a shareholder agreement that you've signed? Or, you know, what sort of things govern the way that you interact with the rest of the shareholders? And they can't answer the question. They don't know, you know, what their rights are fully. And I'm saying not just in a legal sense, but in a even broader, more practical sense. And so those initial conversations, whether it's with the attorney or with the individual client, you know, very, very important to help them understand what they're getting into and what their, you know, realistic options are going to be as the case progresses.
Guys, one of the issues that I see is, once litigation is commenced and once the hold letters are sent, there's an obligation and a duty to preserve certain information. But before that happens, there's an issue there because that obligation doesn't exist under the court rules. And so there's always a risk of document destruction. Obviously, we can ask for documents pre-litigation under the statutes. And one of the questions that I think we're faced with is what kind of information do we need at a basic level for purposes of assessing the value of the company? And then also, what kinds of things that can be done early, perhaps upon demand, shareholder demand, to preserve information from a technical perspective? Computer imaging the computer, helping digital reproductions get made, that kind of thing. So Sean, if you could comment on that.
It's our clients, it's the best interest of our clients to seek preservation as soon as anticipation of litigation is coming. And so really, we work a lot pre-litigation, Mark, to your point, and we help clients identify all the sources of potential ESI that may be relevant. We at least try to get those under preservation right away. We might get them preserved and have them sit for months, years even. But at least we know that we've kind of covered and we froze that date and time. And so there's no issues of spoliation.
Are you seeing a trend in that happening earlier than later in cases?
Absolutely.
Oh, and what about at the pre-filing stage?
We're seeing it earlier and earlier, because I think the judges are becoming more educated on spoliation issues. There's more case law coming out. So I think that the clients and the attorneys are more informed and educated, and to the point that they want to protect themselves in their case.
Yeah. Can any of the attorneys on this panel comment on spoliation of evidence and adverse inferences that they might have seen arising or been faced with in this context? Bernie, RJ?
Well, I'm glad to say that I've never been subject to an adverse inference, but it's a real rule, obviously, and I think Sean raises a very good point. I think the judiciary is becoming more and more aware of the technology that is in play that sort of, I would say, has changed the landscape to prevent this, this kind of default explanation that, hey, I have a routine document destruction policy, and every 30 days, I completely wipe my servers. Now we have a pretty clearly communicated technology that a lot of judges know about to preserve the evidence. So why can't we, maintain the status quo very early on in the dispute, even before litigation, mirror image the flash drives or the other computer devices that actually have this information, so that when it's needed, it's there. But I have read opinions regarding adverse inferences for failure to preserve. And I think the solace there is that we now have technology, albeit at some cost, but it's getting more and more modest, to actually avoid that from becoming an issue as long as you take care of it on the front end.
So it sounds like you're saying, RJ, and I think this is a valid point, that it's not just a way for a litigant to get at somebody else's information, but it's also the way for a litigant or a fiduciary or a prospective litigant to actually preserve their evidence so that they don't run into a situation where, though the case may be weak against them, they find themselves fighting against adverse inferences. If I'm hearing you.
Yeah, absolutely. I mean, it's hey, it wouldn't be the first time that a client may have lost information that you wish you had. So it can also serve as a universe of information for your case.
RJ, I'll piggyback on that real quick. I mean, I'm using it right now. I'll leave the names to the side, but I'm using it as a sword right now. I mean, We sent the classic demand letters, about a year and a half ago, 2 years ago. Give us all these documents, and we added the one-liner in there. Make sure you preserve all evidence. Certainly after the litigation started, we send litigation hold letters to our clients, and my assumption is the other side did the same as well. We should all be doing that as attorneys, whether you're a first year or a 30 year. And then now we've discovered that at a deposition, we had found out through discovery requests and productions that there was just a whole bunch of missing documents. And of course, it comes out at the deposition that the opponent went and actually just deleted a bunch of emails, and that you could see the other attorney's face kind of drop. It's the last situation any of us want to be in as attorneys if we're defending a case. But it's important. And now we're on the cusp. We've filed a motion for spoliation, and we're asking for adverse inferences, which include but aren't limited to that. Certainly all those emails that were deleted would have cut against and favored the oppression that we're seeking. So, so things like that, if your client's not doing it and you're not sending those things on, it comes into fruition. It can really hurt your case. And who knows what those emails would have said, right? RJ, I mean, who knows, right? But now we're on the cusp of potentially getting an adverse inference that who cares what they said? The adverse inference is there, and their case could be shot. So it's easy stuff you can do at the outset, but if you fail to do it or fail to remind your client, it can be bad stuff down the road.
And RJ, I'd throw this in there too. I don't know if you've seen this, but I think one of the other dynamics too is, especially at an early stage in the case, when you make the statement, preserve and protect the following types of documents or ESI, one of the, I think the valid questions that exist there is, well, what are the issues that we need to sort of be looking for and protect information about? So for example, if there are related party transactions who have their own separate documents and emails and so forth, and you're not a shareholder in that entity, but they have information that may eventually be very relevant in the case. If that's not identified, upfront in a shareholder demand, that party receiving the notice may not really have been put fully on notice of what they need to preserve. So I think that dynamic of, what issues you think you're going to end up litigating from a liability perspective, important upfront to think about. And, I would also say from a valuation perspective, what's relevant to value is sometimes pretty wide. There's a pretty wide net as to what kind of documents you might ultimately have some interest in looking at. So I don't know if you've had any experience there with sort of trying to refine the scope of the hold notice, or if the broadest net is the best way to go.
Well, certainly, I would say I don't like a broad net because I think it gives an opportunity for plausible deniability. I mean, especially if the goal is one to preserve evidence and the backstop to that is an adverse inference or some other remedy to address non-preservation, I think you want to be, I think what I do is I create broad categories of items to preserve, and I also narrow within each category here are examples of what needs to be preserved. I mean, I find identifying individuals' accounts, email accounts, to be particularly helpful. It completely eliminates any excuse that the person, wasn't aware that this person's communications, email accounts, Outlook, whatever, may be relevant to the claims. You've identified the name and ideally even the email account, and they lose any sort of shield that they might otherwise have with just a general boilerplate litigation hold letter. And it kind of interlocks with what we were talking about earlier, Tom, is in terms of, consulting both with the client and with your expert as early on in the process as possible, because you don't know what you don't know. And once you do those consultations, it allows you to make more refined litigation hold letters, along with discovery requests. So really, the answer to your question is both. I have a general broad litigation hold letter, but with specific instances of what needs to be preserved.
Got it.
And I guess I would just add, since we have a pause here, is obviously the, you know, the contours.
At least I can see you talking.
Yeah.
Missed your joke.
Yeah, they did.
Oh, hold on. Sean just made a joke.
It was.
We
it was
were
so
on.
good.
We were on mute. So
It was so
what was
good.
what was the joke?
Oh my gosh. No, I said, you talk about depositions. I mean, that's all we have going on in this office is, you know, laptops that have remote depositions going. And so we've really had to really adapt our business as I'm sure all the attorneys have as well. But in particular, I mean, court reporters are going to the office. And so while remote depositions are not new in our practice, certainly the exchanging of exhibits has been new, and we've got a great workflow. We've really thought through the process of how to make it as normal of a process, right? Because the last thing you want to do, Mark, is give all your exhibits to, you know, the witness or opposing counsel prior to the deposition, right?
That's but it's hard to avoid if you're hosting them on Zoom, right?
Exactly. Well, we've come up with a solution that allows our clients to give us the entire universe of documents they may or may not use. We create an index for them, and then in real time, we help them present the exhibits via the Zoom chat feature and the screen share feature. So, you know, we've really had to adopt
So
our
you'll
business.
run it.
Yeah.
You'll run it.
Yeah.
Okay,
So we have exhibit technicians, Eric, who's running this presentation today. We have, you know, 8-10 other people that do this every day, all day. They're not all as techie as you, Mark, you know, so they don't all have a war room like Mark Rossman does, but yeah, we're making it work. And, you know, we've had to buy a lot more laptops. We've had to buy a lot more Zoom accounts. I mean, we have 20 some Zoom accounts. So, you know, our business is really propelled, and we're doing more business than we did prior to this, because I think the attorneys are starting to see it as a viable option as well.
Bernie and RJ, how have you guys been liking the remoteness of depositions and exhibits and documents and all of that?
I love it.
What do you like about it? Wearing your slippers while you depose somebody?
No. I wear my 3-piece suit still, but no,
On the bottom?
what's that?
The bottom of it? Like not a pair of shorts or jeans or something?
Not yet. Sometimes jeans and a blazer, but I'll tell you, I was very reluctant to do Zoom depositions and hearings initially, especially depositions, because of the introduction of exhibits. And I like to be across from the deponent, and I like to be able to handle the documentation while I'm doing the questioning. And I thought that it's a bit awkward to go, you know, through a file on a screen to do that. And I was really amazed at the agility of handling exhibits via Zoom. It is a little bit slower, but I'll tell you, one of my favorite things about electronic presentation of exhibits is I get to control what the deponent sees. And instead of having them go off and look at page number 17 or flip around and look at other exhibits and redirect and kind of commandeer control over my deposition, I'm in control more than I've ever been, in a sense, because I control what they're seeing at any given time on the screen. So, and of course, hey, it's nice not having to drive to downtown Detroit, you know, in rush hour traffic.
Well, if it keeps you in control, that's good, because there's nothing more dangerous than a lawyer in control, right? Or out of control, maybe. So Bernie, tell us, have you had any Zoom snafus, or you tried a case recently, right? In remotely?
I did. I mean, like
How'd it go?
it's basically forced adaption. Okay. We got through it. I think it was fairly successful. You know, we had to do the openings and the directs and the crosses and the closings and all that stuff via Zoom. And there were hiccups, to be sure, but, you know, we got through it, and it wasn't as bad as I guess I expected it to be.
What do you wish you knew at the beginning that you know now from it?
Well, I mean, we were pretty darn prepared. I tend to over prepare. So we had all the exhibits ready to go, but you really have to be careful about what exhibits you're going to use, and making sure the court reporter or the defendant or the other side has the exhibit. So what I ended up doing, Mark, is I prepared a complete set of everything and hard copy mailed it to opposing counsel, to the witnesses, to the court reporter, just in case the share screen on the Zoom didn't work. I could simply have them, turn to page exhibit 22 of the binder I've already sent you. And sure enough, we needed it because, the Zoom kind of cut out. The court reporter had issues. One time I couldn't share my screen. So it was an easy transition for them to actually take the physical book out, go to exhibit 22, turn to page 32 of exhibit 22 and use it right then and there instead of actually having to share the screen. So a little bit mix of old school with the new school worked out well for me.
Yeah, what about in discovery? Have we seen the pandemic affect any of our discovery or practices in terms of timing, how we get documents, access to the courts maybe on motions to compel? More efficient, less efficient, tricks of the trade? Anybody got any thoughts on that? Tom, you're always waiting for documents from lawyers. How's it been going in the pandemic?
For the most part, I would say, most of what I'm getting anyways is electronic. So most is not coming through paper. I think, frankly, one of the things about that in particular, though, is that it's much harder to schedule a shareholder meeting that has substantive, conversation and communication. I know that's one of the things that sometimes you may think about as part of a pre-litigation effort to either resolve a case or to figure out what you're going to put into your complaint. But that whole process of getting in front of the other shareholders and trying to hash things out, or at least get positions staked out, I think that's definitely been more complicated, frankly, for me, more so than looking at traditional discovery documents.
Let me pose a question. So it's initial disclosures versus document and discovery requests. Where do we fight for our information? Do we argue that the initial disclosures are insufficient and really make a press for documents and information at that stage? Or do we accept their initial disclosures and just kind of wander out into discovery and start issuing requests?
So Mark, I can speak to at least my experience. I think most of the folks that I've dealt with, everybody just kind of gets out their initial disclosures just to comply. And then it's back to discovery requests 101. People are still sending their requests out, even if it's duplicative, and the other side's doing the same thing. And the battles are being fought on kind of the first round of discovery requests still. I haven't seen anybody really press too hard on the initial disclosures because, candidly, I think people are just kind of checking the box on that and moving to what they know. Will that change? Maybe, as the court rules are still new and people are still navigating those things. But I think a lot of folks, a lot of practitioners, and I'll say myself included, are really going back to what we know, and that's really getting into the discovery that you send out.
Yeah. What about the difference between the third party and the first party discovery? I have a strategy of going after what I call BBA, the bank, the bookkeeper, and the accountants, because I find there's a lot of plentiful information in there that might just for some strange reason not be in the defendant's files. And so if you get comments sort of on third party discovery practice, just in general, and also coordinating it in the pandemic, which I find to be somewhat difficult in dealing with service issues and that kind of thing.
Well, Mark, one thing to add on the prior topic, I agree that the initial disclosures are not, I don't think they're very helpful. They're just too generic. Some jurisdictions like California actually have specific disclosures required by subject matter. And I think if we had oppression disclosures, disclosure requirements, particular to oppression claims, I think they would be much more productive and save actually a lot of costs. A lot of the information is repeat in most, oppression cases. You don't have the same issues, but you have overlapping issues often. In terms of third party, and I would say, I think there is one substantive initial disclosure in oppression cases, and that's computation of damages. For a plaintiff in particular, you have to do a computation of damages as part of your initial disclosures. You can come up with some explanations as to why those can't be, why that computation can't be done because of lack of information, for instance. That's a classic issue of a plaintiff in an oppression case. I don't know exactly what my damages are because I've been frozen out of the business and information that I need to calculate that. but certainly in some instances,
RJ, on that point of damages, I don't want to forget this, but would the valuate, I think there's a serious question as to whether the value of a company in a shareholder case actually is damages, and whether that would need to be included in there. Do you or maybe Tom have any thoughts on that, or whether that would fall within the sort of equitable relief that the court held existed in the Matagula case when it stripped the minority plaintiff of a jury trial? So really is the valuation component, which we talked about earlier, is that really damages that would need to be disclosed at that point?
Well, I mean, I don't know the answer exactly to that question, Mark. I was involved in Matagula and testified on the valuation issues in that case. And that, like, frankly, many others, there's almost no way to put together something that is reasonably well done at an initial stage on a value question for, in particular for a party who has limited access to anything more than a financial statement. Damages, to the extent that they're different from value, same issue. I mean, I think there's, certainly some cases where you've got a narrow issue, a very, specific thing that an informed plaintiff, let's say, might know about, that they can articulate, that you can measure in very discrete terms. But, realistically, putting together a damages analysis, for example, on, let's say, related party transactions, or alternatively, a valuation analysis for an ownership interest, very difficult at that early stage. So it's kind of going back to the comment I made at the beginning. It's great to have an ability to help your client understand scope and help them understand the issues they're going to deal with. But, to actually be able to quantify a lot of that stuff early on in an initial disclosure is not quite as bad as throwing darts, but close.
So Tom, if I want to speak freely with the expert on the case before the case gets started, and I'm not quite sure even if we're going to have a case, and I don't know if the expert will be a testifying expert, how do you structure those types of arrangements so that we can get open and candid written work product from our advisor, our expert in this situation, and not necessarily have to produce it in the initial disclosures or in discovery?
I mean, I think there's a lot of,
and
different
have the option to transition to a testifying expert.
Right. I mean, there certainly can be scenarios where you retain someone to function as a, what someone would call a consulting expert. Typically their work product is not discoverable up until some point in time, or maybe never, but that depends. And I think you see some creativity that happens in certain situations where, let's say, a firm will take one person that's an employee and call them the consulting expert, and then some other person that works one door over is the testifying expert if it goes that far. I'm not sure if that necessarily is compliant with the rules, but anyway, I think that initial stage can be sort of in that consulting expert role. And again, I think, frankly, everyone benefits by having some knowledge up front from someone who's got some perspective and some expertise with the financial side of the case. Whether that then translates into a difficulty down the road, if you give an initial consultation or initial set of perspectives, frankly, it's almost, like I said before, almost always colored by the limited information that you have at that stage, and it almost inevitably will change.
So RJ, once the case is up and running, what kind of how do you determine your discovery strategy and your approach to these types of cases? Getting the documents you need, getting the testimony. Do you wait for all your documents before you take your testimony? Do you think getting people under oath quickly is beneficial? Broad observations, but I've done discovery against you, so I know you got a few tricks up your sleeve.
Oh, nothing too novel. I don't believe in cookie cutter approaches to discovery. Even if it's, an oppression case, I don't think cookie cutter, discovery works very well, because then you get cookie cutter responses. So I tend to like to do written discovery first, and the nature of the suspected alleged oppression is going to, I think, dictate or at least inform the nature of the discovery, just like in any other case. You know, a freeze out oppression case is not going to be the same, have the same discovery necessarily as an inadequate redemption price oppression case. And you know, what I broadly, you know, looking at discovery in an oppression case, I try to find the snapshots in time and the evidence that relate to snapshots in time when we're talking about, you know, financials or decision making. And I try to then look at, well, what is the video reel? What's the reel look like? Because when we're talking about, you know, unfair conduct, you know, it's that sort of subjective term. I think you have to look at comparisons. It's not only whether, you know, a certain transaction or decision was fair for, you know, a particular shareholder at a particular instance in time, but how does that compare to how other shareholders were treated? How does that compare to, you know, shareholders who are family members? How does that, you know, compare to shareholders who are running the company or in the control group? And so I try to get the instances, the snapshots, and the discovery that pertains to it, as well as understanding the broader context and picture in which decision making is occurring, so that I can better ascertain what exactly happened here and best make my case. Now, I'm talking from the plaintiff's side, and I guess because there's more meat on the bones there, the defense side is almost the inverse, right? Is you know, it's hard to prove a negative. I did not oppress. I did treat them fairly, and I have a simple philosophy: the truth will set you free. I mean, if you want to have a defense in terms of how you proceeded or had a good business judgment that was exercised, you're going to provide this information.
All right, that's the warning sign that we have 90 seconds. So in that time, one issue we didn't touch on, but I thought we should, is the remedies that we seek in this case and how important it is to define them early on. Obviously, where there's buyout, but there's a whole host of other ones. So if anybody can comment on that, I think that'd be a nice way to close it out.
I can comment, Mark. I mean, I think this just brings us back to the beginning stage. We haven't filed a lawsuit. I think you need to ask your client, what do they want? It's a simple question, but sometimes we as attorneys maybe fail to ask it. You might have a great oppression case and it might be worth a lot, but the person you're speaking to might define victory as, I just want my dad, the majority owner, to keep me in the loop. Mm-hmm. So you really need to define and manage client expectations and find out what the client wants. And from there, your strategy, how you address it after the fact, is kind of dictated.
All right. Well, thank you very much, gentlemen. The wrap on the first roundtable, and the next one will be up in a couple of minutes.